the Town of Plattsburgh Town Board to order for September 15, 2008. With a roll call, please.
Bernard Bassett.
Here.
Thomas Wood. Sheila Brockway.
Here.
Gerard Benedict.
Here.
Martin Mannix.
Here.
James Coffey.
Here.
We need to, on these notes, we've got 6:10 in there. We want to correct that to 6 p.m. That's from our last meeting. Copy and paste it, didn't get deleted. Resolution 08-288.
Resolved that the minutes of the September 2nd and September 8th, 2008 meeting be approved and the reading of the minutes be dispensed with.
The motion?
So moved.
Ms. Brockway, would you like to second that, Mr. Mannix?
Yes, I will.
Any discussion? If not, we'll have a roll call.
Sheila Brockway.
Yes.
Gerard Benedict.
Yes.
Martin Mannix.
Yes.
Bernard Bassett.
Yes. This is the portion of our meeting where we ask if anyone would like to address the board. We welcome them to do so, please stating their name, address, and limiting their comments to 5 minutes.
John, St. Germain, 2391 Route 3, Katyville. The reason why I'm here is there seems to be some confusion over the zoning ordinance and the placement of the political signs. When I was on the committee for the zoning, to change the zoning ordinance, we had made some changes, and that was one of them. And supposedly they weren't supposed to be put in any public right of way. On Wednesday morning, the 3rd of September, I noticed there were some signs in the public right of way, or what I thought was the public right of way. I notified the codes enforcement officer, and he said that he would take it up with Mr. Bassett, the supervisor, which I understand he did. Out of that came, that evening, I was told that it was decided that the signs could stay up for 45 days or longer because they were put up for the primary or what have you. But also, the part that I wanted addressed was the fact that the zoning law itself states that no signs, permitted bills, or other advertising shall be affixed to any tree, utility pole, power pole, or placed in any public space or public right-of-way. Signs promoting or advertising a person or party for elected office or an event shall be removed within 3 days after the applicable election event. The second part of this really doesn't pertain to the zoning ordinance other than it says that you can have them. In the letter that I have, here's a copy of the amended zoning ordinance with changes marked in red. Please review. Thank you, Bill Flynn and C.J. Madonna. New in red. H is in red. Posting prohibited. No signs, printed bills, or other advertising shall be affixed to any tree, utility pole, power pole, or placed in any public space or public right-of-way. All of these signs that I've seen basically were in the public right-of-way, or were where they shouldn't be. At the time that we had these meetings, we met twice a month for 6 or 8 months. I know myself, Mr. Wood, I know Mr. Coffey was there, Mr. Madonna, and a few others, and that we had agreed that we would no longer allow political signs in the public right-of-ways. We were trying to eliminate them along the highways and what have you. We fully understood that you can't just single out political signs themselves. You have to do it with all temporary signs. And that's why the law read as it did. And I was wondering, I went and I met with what the procedure was. I went to the planning, or the zoning board meeting the other night, and I was told that I had hoped to get a ruling on what a right-of-way was. Unfortunately, we didn't spell it out in this ordinance. I then asked, at that point, after the meeting was over, I asked, well, all the planning board, our zoning board members were there, and C.J. Madonna, if it was possible to, get a ruling on this. And they really didn't want to. The feeling seemed to be that you could rule whatever way you wanted to. So I didn't know what the next procedure was. So this afternoon I stopped into Mr. Imhoff's office. Don Lee wasn't in. And after we talked for probably 5 minutes, Mr. Imhoff said you had to bring it to the town board. So that's where I am. So Mr. Imhoff seemed to feel that I had an agenda. He said, your signs were up all over the town last year and everything else. And I said, well, Steve, last year they were allowed. The law didn't get passed until October. They were grandfathered in. Then I basically, he let me know that he felt I was wasting his time, and I said I was sorry for wasting his time and apologized, and left, even though I was trying to find out what the next procedure was. But I guess what I'm looking for now is can somebody tell me why the zoning ordinance hasn't been upheld? As far as I know, it's very, very clear. No signs, printed bills, or other advertising shall be affixed to any tree, utility pole, power pole, or placed in any public space or public right-of-way. I would assume that the town chairmen and county chairmen would have been notified that the town of Plattsburgh had new zoning laws and that these signs would have been prohibited.
I'll react to that kind of briefly, John. Mr. Lee, Don Lee, and I did get together trying to come up with a response. Don put together pretty much the text of what ended up going out. We tried to react to what was intended. There's also some question because there's a section I don't recall offhand of exemptions. And political signs are mentioned in there. I didn't feel they were exempt because it was noting is that the signage had to be removed within 3 days after the election. But there is also an opinion that the fact that they're mentioned in there means they're exempt. We're also dealing with some issues that might need further research relative to our Board of Elections, but more important, any state laws, or maybe even any federal relative to election laws, to make sure we don't interfere with that. Mr. Lee and I both made an interpretation of what was written. And you're right, it's not always clear what a public right-of-way might be. In my mind, the roadside is an easement area. It's not necessarily a public right-of-way. It's not a public access from point A to point B. It's not a path to get from the parking lot to the beach sort of thing, which we wouldn't want signage to obstruct individuals from being able to access and move through a public right-of-way in that nature. And I'm not sure what there is out there with other law rulings that might supersede the right of individuals to put these temporary signs. So what we did is we reacted in the way that we thought was best. Don came up with the statement, and I concurred with it, and we made sure that that was shared with the Board of Elections at the county level, as well as the county party leaders, so everyone was aware of that. I don't know, I mean, the other answer, another part of your question, who's going to make a decision on that? I think the Zoning Board of Appeals would be the one to do that. It would have to go before them, and I would encourage them to take their time, research that deeply to make sure that the code itself is in complete compliance, which, you know, there's nothing that I've assumed it isn't, but certainly our knowledge base changes over time. But until then, we had to give everybody, you know, something to work with, and felt that was the fairest way to go at it.
Well, in the legal FAQs, the placement and removal of election signs, what regulations can a town adopt regarding the placement and removal of election signs? A town may adopt reasonable, content-neutral time, place, and manner restrictions for the placement and removal of signs that apply equally to all temporary signs.
And I think having the 45-day, you know, decision, which the town simply wanted to try to avoid people putting political signs out in July, and 3 days to get them picked up, was pretty reasonable. And what Mr. Lee did is try to find, again, a reasonable interpretation of what public right-of-way would mean to imply, and that's what he did. I think anything beyond that, you know, certainly this board can't rule on it. It would be the other board.
Well, the public, the 45-day thing has always been part of the zoning ordinance. That never changed. The 3-day thing never changed. What did change was, and in red, added public or public right-of-way. Now, a public right-of-way, according to the state, according to the county people, is the right-of-way that the highway is built on, not the pavement area.
I don't know
not the
that.
sidewalk.
They haven't told me that, and I don't know if that would be the same ruling of
If
the
you want to
town.
call any of your county, state, or even your own town,
It's still something that that board would have to act on. I felt comfortable with what our codes enforcement officer, you know, saw as what was fair and reasonable interpretation, and had shared that with Mr. Vidana, the you know, attorney, and he felt that was appropriate also. And if there's you know, question, then again, it would have to go before that board, and they'll have to act.
So,
I just would ask that they don't act too
And I
rapidly.
was told today by Mr. Remoff that this is what I had to do, and that you people would bring it before the zoning board. Is that the procedure?
If you want to make a formal request that they review that, which it sounds like you already did, then...
No, I was told that the way the procedure was to go to you and address you, and that the town board would be the one that would make the decision.
So you'd like an interpretation of exactly where is the public right-of-way, and does that include roadsides? Is that correct?
Right.
Okay.
Because the thing is, I think all along that, you know, if that is the case where the roadside is not considered public right-of-way, then our putting in the public right-of-way did nothing, and the zoning ordinance is right back to where it originally was before we ever made any changes.
I mean, my personal decision on that would not have been with my personal interpretation that it met alongside the road. There are an enormous number of temporary signs, everything from children with lemonade stands selling fishing worms and garage sales, that would be included.
And we discussed that at great detail, because I said to Don, this is going to be a terribly hard thing to enforce. You got realtor signs, you got
Absolutely.
garage sale signs and everything else, and he said, look, he said, that's a hazard, a safety hazard. People pull off to these garage sales, and they don't get all the way off the road, and it's a problem.
Now, if they have their sign on their lawn, you're still going to have that same problem, people pulling over, so...
Well, yeah, but the thing is, I think the intent of this was to prohibit the influx of a tremendous amount of elected official signs all along the highways, both sides of the road, and what have you. That was the intent. And we couldn't single out political signs, so we had to do everybody.
And I'm not even sure that
Jim, you were there,
election
you
law will
know
allow
what the
that.
intent was.
Well, first of all, John, I think I told you I wasn't there at all in the meetings, but I think the question's very simple. You have a question regarding the interpretation of the zoning code and the procedure for doing that. And if you have a question, that's the route is through the zoning board of appeals. And that's the route. It's not a town board decision. Now that you've expressed it, I'd be happy to take a look at it or something, but my opinion wouldn't carry any more weight than anybody else's opinion than your opinion.
We need to have Mr. Pagano
Well,
research that. and bring it
it's a
before the board.
zoning issue that has to go through the zoning board of appeals. The town board doesn't interpret the zoning law.
We'll pass
And
that.
if you didn't
I
like-
fully realize
Yeah.
that, but the other problem is with this immediate release, where the supervisor and the codes enforcement officer basically extended the time that you can leave signs up, and they don't have that authority to do that either.
Well,
Only the zoning board
whether
has
they
that.
do or they don't, your remedy is through a court of law. I mean, you have to go through these procedures, not through the town board. And that is the remedy.
If I could comment, I'd also like to point out, I think this is a particularly good year for this new law to be looked at, and we're seeing what are, as you yourself said, you were trying to point out from an enforcement standpoint there would be some problems, and I think you were correct. But, I mean, we don't have a proliferation of candidates this year. I mean, you look forward next year, you're going to have local elections going on, you're going to have more candidates involved, you'll have more signs involved, so it's a good time for this to be looked at. But, I mean, I drive around the town right now, I see signs from both candidates that are in similar locations, okay? I also see signs, I see other signs, I see signs like Bunny Walk, and those signs are in the same locations as some of the political signs. And so it's the right time for this to be looked at. But that's exactly what needs to happen. They need to take a look at it, they need to work with their legal counsel, come back with an interpretation of that ordinance as it was amended.
But I know that at the time that I served in that committee, the intent was to eliminate the elected, the signs for elected officials along the roads as much as possible. And that was where the enforcement was supposed to be, the greatest amount. And I know Tom Wood was on that committee. He said most of his signs he puts on private property anyway, and he was in favor of it. And I thought you were, Jim, and I thought Don Lee was, and I thought CJ was. But obviously, that wasn't true.
I don't think that was the case. I think that the case comes down to the definition of the term.
Well,
What do you
no,
mean
the
by
case-
what is meant?
Usually it's
And it's
what
not
is
your
the-
definition or Bernie's definition, it's what's the
Usually it's
definition?
what is the intent of the law? When in that committee, what was the intent of the law? And that was the intent of that being put in there, because otherwise it wouldn't have had to be put in there.
But it may not have been done effectively. In other words, the choice of words may not have been the appropriate choice of words.
Well, and as we voted on that, if that was the intent, my vote would have changed, because that wasn't my interpretation. And I
Well,
certainly
this-
wouldn't
and
expect
that-
any primary candidate to put signs out to promote their campaign, pick them up and put them out again. And some of that is just needing to be clarified. Nothing was even mentioned in there. But I will, get a letter out to the zoning board, and I think we got very specific things for them to look at, and we'll let them look at it.
Yeah, unfortunately, when we passed this zoning ordinance, we didn't. In a work session, we looked at it for about 5 minutes, and that wasn't enough.
Well, you're picking one section out of something that had a lot of pages to it, and that sometimes the details get lost.
Just if I could, one question. Steve, do you have the zoning ordinance with you?
Yes.
Is there still exceptions in there for
Yes, there's
political signs,
exemptions.
realtor signs, and contractor signs? I believe that was in the original one.
Now that Mr. St. Green has addressed you, if that's his opinion or that was his take on it, I informed him to come to you guys, to Mr. Bassett, and do a formal request to you guys, it'll go in front of the zoning board of appeals for an interpretation, and CJ and the planner, or the codes department can sit down and review it and see what the true intent was. His interpretation is different somewhat than other people's, but there has to go from step A to step B in front of the zoning board. When Mr. St. Germain came in last Wednesday in the zoning board of appeals, he wasn't on the agenda. The board had adjourned and then came in for this. It was done. They can't rule on it. They can't. One board member's going to have a different thought of what the true intent was than another one. So this way it can formally be brought up in front of the zoning board of appeals and dealt with there, and CJ can do the review of it.
Yeah, they need time to process, to gather information. You know, there's other statute that needs to be considered as we interpret, you know, whatever we think our intent was. That can't be hastily rendered. But what Mr. Lee and I did is we needed to respond, and we did, in a way that I think was reasonable and fair. Anyone else wishing to address the board this evening?
I'm Debbie Blake, and I live in Cleveland. And I hadn't planned to address the board, but it's in relation to what Mr. St. Germain said and the discussion that was at the town meeting last week about the definitions of a public right-of-way and an easement. And Mr. Coffey knows very well what they are. He teaches real estate at State University here. I believe at one point I asked Mr. Bassett if the area in front of my house on the side of the road was a public right-of-way, and he said, no, that's an easement. But in fact, it is not an easement, it's a public right-of-way. An easement is something that is owned by one person and used by another. I don't own that. The road bed is 50 feet wide. The road is only 20 feet wide. The town of Plattsburgh owns 15 feet on each side of the road. I asked the head of the highway department, and that's exactly what he told me. I called DOT, and that's what they told me. DOT also, I asked them, how do they determine what is public right-of-way? And they said, where our road is. I said, how wide is the road? How much property do you own? They said, it depends on how much we purchased. And if the road is 1 inch wide and the property we purchased is 50 feet, there's still 49 feet and 11 inches of right-of-way on the side of those roads. And I said, well, is that public right-of-way? And they said, it's owned by the government. Of course it's public right-of-way. You have public property and you have private property. If it's not a public right-of-way, it's private property, and you're not supposed to put your signs on private property unless you have permission to put them on private property. And I find it rather disingenuous since, Mr. Bassett, you had some signs last year on what you called a public right-of-way according to the police report. And the property on the side of the road. And you knew last year what a public right-of-way was. And it's very disingenuous to say that it's not a public right-of-way issue. If it wasn't a public right-of-way, then it was private property, and the person had the right to remove the signs from the private property.
Anyone else? Let's get on with the business of the evening. Resolution 08-289.
Resolved that the abstract of audited claims number 9B in the amount of $678,561.78 be received as reviewed by the audit committee, and the supervisors hereby authorized to pay said abstracts.
Have a motion?
So moved.
Mr. Renadette, second. Ms. Brackley. Any discussion? Roll call.
Sheila Brackway.
Yes.
Gerard Renadette.
Yes.
Martin Mannix.
Yes.
Herbert Bassett.
Yes. Resolution 08-290.
Resolved to receive and place on file the supervisor's financial report for the month of August 2008.
Have a motion? Ms. Brackway, second.
Second.
Mr. Mannix. Any discussion? Roll call.
Sheila Brackway.
Yes.
Gerard Renadette.
Yes.
Martin Mannix.
Yes.
Herbert Bassett.
Yes. Resolution 08-291.
Resolved to receive a report from Amy Duquette, Town Clerk, for the month of August 2008.
Have a motion?
So moved.
Mr. Renadette, second. Ms. Brackway. Any discussion? Amy, I was reading in the newspaper today that hunting and fishing licenses are up, linking that to the economy and so on. Have you seen any increase here as well?
I don't know what, a little bit of an increase. I think I don't know the exact numbers until the season's over. but I believe so.
Just curious. Everyone's turning to the woods to cut the grocery bill. Of course, the price of ammo, and I'm sure licensing and guns and everything else is up too. Any other discussion? Roll call.
Sheila Brockway?
Yes.
Gerard Brennan?
Yes.
Martin Mannix?
Yes.
Bernard Bassett?
Yes. Resolution 292.
Resolved to receive and place on file a report from Don Lee, Codes Enforcement Officer for August 2008.
A motion.
So moved.
Mr. Brockway, second.
Second.
Mr. Bernadette. Any discussion?
A lot of new greens this was going on in Woodstock. See that?
If not, to roll call.
Sheila Brockway?
Yes.
Gerard Brennan?
Yes.
Martin Mannix?
Yes.
Bernard Bassett?
Yes. Resolution 293.
Whereas the town board of the town of Plattsburgh has heretofore on the 4th day of August 2008 adopted a resolution consolidating the town of Plattsburgh Consolidated Water District and the Archie Bordeaux Water District and extensions thereof into a single consolidated water district pursuant to provisions of Section 206 of the town law of the state of New York, and said resolution was adopted subject to a permissive referendum. Whereas no petition for a permissive referendum has been received within 30 days after the adoption of the aforesaid resolution, and after posting and publication thereof as required by Section 206 of the Town Law of the State of New York. Whereas the action undertaken herein is a Type 2 action requiring no further review under Section 6 NYCRR 617.5. Now therefore is ordered, resolved, and determined that the Town of Plattsburgh Consolidated Water District and the Archie Bordeaux Water District and extensions thereof are consolidated into a single consolidated water district pursuant to the provisions of Section 206 of the Town Law of the State of New York, and known as the Town of Plattsburgh Consolidated Water District, and consolidation shall be effective as of December 31st, 2008, pursuant to provisions and determinations as made by this board. And its resolution dated August 4th, 2008. And it is further resolved that the town clerk is directed to cause a certified copy of this resolution to be recorded in the office of the clerk of the County of Clinton within 10 days after the adoption thereof.
So moved.
I'll second.
Get the words out of my mouth.
I'll second it.
Ms. Brockway will second that. Any discussion? This, I think, is the last resolution in a long trail that began some time ago with providing water to the residents out at the Archie Bordeaux area and getting them into the consolidated district. So, hallelujah. A roll call.
Sheila Brockway?
Yes.
Gerard Brennan?
Yes.
Martin Mannix?
Yes.
Bernard Bassett?
Yes. Resolution 294.
Whereas the town board has previously authorized the improvements required for the Champlain Park Pump Station upgrades, and whereas bids for Champlain Park Pump Station Contract Number 1, General, were received on August 19, 2008, whereas the consulting engineers, LaBerge Engineering and Consulting Group, have submitted their report relative to their analysis of bids. Now therefore be it resolved that the recommendation of said engineers be hereby accepted, approved, and adopted. And it be further resolved that the Champlain Park Pump Station Contract Number 1, General, be hereby awarded to Luck Brothers of 73 Trade Road, Plattsburgh, New York, in the base bid amount of $1,513,900.50. And it be further resolved that the supervisor be authorized to reduce the contract amount in allowance with the engineer's recommendation in the event that NICEAG opts not to have the force main trench and/or if the amount of directional drilling can be reduced.
Have a motion.
So moved.
Mr. Renadette, second.
I'll
Ms. Brockway. I'd like to make sure note, it wasn't in the resolution, but in Mr. LaBerge's letter and recommendation, he does note that this was the low bidder for the project. Any other questions? We have another resolution for awards, but we also, I'd remind you, we look at some pretty big numbers here, but we do have some grant money, and we did get through some final approvals for over $1 million from EFC that will be at 0% interest, which is going to be a significant savings. We're still working on that relative to, other ways to offset the cost.
And I think it bears mentioning too that even though we had passed a resolution to increase the amount of, that we could bond for this project, the project total, even with the next resolution came in under the $2 million that we had initially earmarked.
Yeah, it's under the original, that's right, we're on the 2.5, so we
thought it was going to be over that, so we had passed a resolution for an additional $500,000 of bonding, but the total comes in at under the $2 million, which was initially set aside.
I know after we had that other issue with the Moffa Road, the consulting engineer was pretty pleased that their numbers this time held very well for them, so that's a good point, George.
Correct me if I'm wrong, but it seems to be one of the other benefits of this resolution is it allows NYSEG and Luck Brothers to enter into their own negotiations regarding accommodating the placement of their pipe in that trench if that is what NYSEG decides to do.
Right. And we are continuing conversations with the county about the amount of drilling that they are wanting us to do. That's not firm yet, I hope. So that could be altered some. But we do need to be going forward and have this awarded. Anything else? Roll call.
Sheila Brockway.
Yes.
Gerard Renstedt.
Yes.
Martin Mannix.
Yes.
Bernard Bassett.
Yes. Resolution 295.
Whereas the town board has previously authorized improvements required for the Champlain Park Pump Station upgrades. And whereas bids for Champlain Park Pump Station Contract 2 electrical were received on August 19, 2008. And whereas the consulting engineers, LaBerge Engineering and Consulting Group, have submitted their report relative to their analysis of bids. Now therefore be it resolved that the recommendation of said engineers be hereby accepted, approved, and adopted. And to be further resolved that the Champlain Park Pump Station Contract Number 2 electrical be hereby awarded to Mountain Lake Electrical of 102 Trade Road, Plattsburgh, New York, in the base bid amount of $138,450. And it be further resolved that the supervisor be hereby authorized to accept, and he is hereby authorized to sign all related documents relative to the award of said contract.
We have a motion.
So moved.
Mr. Bernadette, second.
Second.
Mr. Mannix. I'd also note on this one, Mr. LaBerge references in his recommendation that this was also the low bid for that project. And we do have EAP approval. Any other questions? Roll call?
Sheila Brockway.
I have to recuse myself from voting on this.
Gerard Renstedt.
Yes.
Martin Mannix.
Yes.
Bernard Bassett.
Yes. Resolution 296.
Whereas the town board has received correspondence from Don Lee, Code Enforcement Officer, regarding abandoned, unsafe, and unsanitary conditions around and in the dwelling at 19 Sorrel Avenue, owner Martin and Sonia Crawford. And whereas Mr. Lee has requested that the town board take action under local law number 1 of the year 1983 regarding unsafe buildings. Therefore be it resolved that the town board does hereby authorize the Code Enforcement Officer to take actions necessary to abate the unsafe conditions as required in the aforementioned local law. And it is further resolved that by order of this resolution, the junk and debris be picked up and hauled away with the cost thereof to be levied upon the taxes of this property in accordance with local law number 1 of the year 1983, entitled Unsafe Buildings Law. And it is further resolved that Mr. Lee report to the town board with actions taken and timetables for compliance and completion date of such action.
Have a motion?
So moved.
Mr. Brockway, second.
Second.
Mr. Mannix. Any discussion?
Just like to offer that it's unfortunate that this has to take place, but this is a piece of property that has been severely neglected for, I would say, about 5 years ago. I think this was an issue during a campaign, probably 5 years ago, where, there was some concern as to whether or not we should take action then, and the board was made to appear that we were unsympathetic. And since that time, nothing has happened. It's gotten worse. The tree that's been growing up in the middle of the house has gotten bigger. The weeds have gotten taller, and I guess it's finally time that we have to move forward. I would hope that everybody realizes that this is not something that the board wanted to rush into. We've taken our time with it. Nothing has happened. We've given every opportunity for something to happen, and it just hasn't. So it's now time to move forward.
You know, and I commend the codes office. God knows they have enough on their desk without going out there and looking for some of these projects that aren't, sometimes aren't a lot of fun, but I think we mentioned before we did some similar work with residences in Champlain Park. We had the Dominic's Restaurant. The message we want to send out is this community wants to be respectful, wants to send the right message to visitors, to those who live here. We're patient. This, as you said, probably could have been aggressively attacked sooner, but you want people to do the right thing, and ultimately you draw the line, and that's it. And I feel pretty confident, having followed what Steve has done with some previous properties, I feel pretty confident the T's will be crossed and the I's dotted very well on this, and we won't have any, problems as a result. So, let the message go forth. We have some rules, and sooner or later, we have to deal with it.
I don't know if you guys are familiar, it's say 1940, 1950 single-wide mobile home. Before, I think it's only like 10 feet wide, 44, 45 feet long. The guy hasn't lived into it. 5 years, I'll give it 7, probably 8. It was during Andy, when Andy was one of his last
I think one of the points that was made, Steve, was the guy was in a VA hospital and we were not being fair to veterans, but
Is he still, the taxes still being paid?
Yes. The daughter's son, I think it's Sonia, she is the estate, she takes care of the estate. They come up here once every 2 or 3 years, but the guy next door, trying to blank, he drives concrete truck for Draymond. He maintains it, mows the lawn, but he gets to park his RV and he's got some antique cars, so he doesn't mind because he gets a little extra land. But the home is old, tired, now it's become a fire hazard. One kid gets in there and stuff's been sitting vacant for a while. It's going to affect his home, so it's time to finally act on it.
Thank you. Roll call.
Sheila Brockway? Yes. Gerard Rentek?
Yes.
Martin Mannix?
Yes.
Bernard Bass?
Yes. Resolution 297.
Whereas the town of Plattsburgh has a vacancy in the position of clerk typist, and whereas the position of clerk typist was duly posted and interviews were conducted based on a list of qualified candidates received from the Clinton County Personnel Department, and whereas interviews for the aforementioned position were held by the Supervisor Personnel Committee, Mr. Phil Von Bargen, Mr. Alan Reese of the Planning Department, and whereas the interview committee had made recommendation as to the selection of the appointee for the aforementioned position. Now therefore it is resolved that the town board of the town of Plattsburgh hire Ms. Tamara Shepherd as clerk typist effective as soon as possible to step 1 of the 2008 pay scale pending civil service approval with a probation period of 6 months from her initial date of employment. And it is further resolved that the supervisor is hereby authorized to sign all necessary documents for the hiring of Tamara Shepherd. And it is further resolved that a certified copy of this resolution be forwarded to the Clinton County Department of Personnel for civil service final approval and filing.
A motion?
So moved.
Ms. Brockway, seconded
second.
by Mr. Renadette. Any further discussion? I think the recommendation is a good one, and we certainly look forward to welcoming Ms. Shepherd and getting off to a good start for the new position. Roll call. If this
Sheila
passes.
Brockway?
Yeah,
Yes.
the vote.
Gerard Renadette?
Yes.
Martin Mannix?
Yes.
Bernard Bass?
Yes. Now I congratulate her. Resolution 298.
Whereas the town of Plattsburgh has a vacancy in the position of senior code enforcement officer, and whereas interviews for the aforementioned position were held by the supervisor of the personnel committee, members Sheila Brockway and Thomas Wood, and whereas Stephen Imhoff has held the position of codes enforcement officer for 8 years, and whereas the interview committee has submitted a letter of recommendation and support for the appointment of Mr. Imhoff to the aforementioned position. Now therefore be it resolved that the town board of the town of Plattsburgh appoint Stephen Imhoff as zoning and code enforcement officer effective October 1st, 2008, as step 8 of the 2008 pay scale, pending civil service approval, with a probation period of 6 months from that date. And to be further resolved that a certified copy of this resolution be forwarded to the Clinton County Department of Personnel for civil service final approval and the budget officer for filing and implementation.
A motion?
So moved.
Mr. Renadette, second.
I'll second.
Ms. Brockway, any discussion?
You ready for this?
Yeah. in the interview, he did really well.
Did you ask him any tough questions?
No. He already had all his resume up to date and it was well defined.
He's been doing the tough job for a while, he knows what he's getting into. Just the heat goes up a little.
I think he's been doing an excellent job, but he's
A couple years in that job, you'll be qualified to become dog control officer.
Maybe.
Maybe we'll add
We
that.
maybe combine the departments.
That's what I was just thinking, maybe we could add
Shared
that.
services.
If there's no other discussion, roll call please.
Bill Brockway.
Yes.
Gerard Renfro.
Yes.
Martin Mannix.
Yes,
Leonard Bassett.
Yes, congratulations, Steve.
Thank you.
well deserved.
Thank you all.
Resolution 299.
Whereas the town of Plattsburgh Town Board previously adopted local law number 3 of the year 2003, regulation of wireless telecommunication facilities. And whereas local law number 3 of the year 2003 mandates that no person shall operate, establish, or maintain wireless telecommunication facilities until he has obtained a special permit to operate a wireless telecommunication facility and has obtained a certificate of approval for the location of such wireless telecommunications facilities. And whereas the town of Plattsburgh Town Board did refer an application by Bill Santo Wiring Hometown Radio to operate an AM station wireless telecommunication facility on New York State Route 9 South to the Town Planning Board for review and recommendation report. And whereas on September 9, 2008, the Town Planning Board by Resolution 0861 did recommend for the Town Board to favorably consider the Wiring Hometown Radio application subject to the Town Planning Department list of recommendations letter dated September 9, 2008, and other recommendations noted within the resolution. And whereas the Town of Plattsburgh Local Law Number 3 of 2003 requires the Town Board to schedule and give notice of a public hearing for all persons within 1,500 feet wishing to be heard regarding the special use permit application. And whereas the General Municipal Law, Article 12, Section 239N requires local law authorizations be referred to the Clinton County Planning Board if the action is within 500 feet of the City of Plattsburgh municipal bordering or within 500 feet of a county or state right-of-way. And whereas General Municipal Law, Article 12B, Section 239NN requires special permit notice to an adjacent municipality when a hearing relating to the issuance of a proposed special use permit on property that is within 500 feet of an adjacent municipality. And whereas the proposed project location is within 1,000 feet of the City of Plattsburgh, but greater than 500 feet distance from the municipal corporation's limits and exceeds the distance required for GML 239NN notifications. Whereas Part 617 of the Environmental Conservation Law, State Environmental Quality Review Act, Section 8-0113 provides for the review of any action to be determined, or any action to determine the effect of said action on the environment, along with any related administrative procedures for the implementation, authorization, or approval of said action. Whereas Part 617 of the Environmental Conservation Law provides for an involved agency to review any action for the purpose of determining the effect of said action on the environment. And whereas said determination of the effect of said action on the environment will be necessary to determine whether a draft environmental impact statement is required. And whereas the town board has considered an involved agency in accordance with the state and local laws for the purpose of assessing of the effect of this project on the environment, and whether or not that effect is significant enough to warrant the preparation of draft environmental impact statement. And whereas the town board has identified that the project entitled Wiring Hometown Radio is located substantially contiguous to the National Historic Landmark known as the Plattsburgh Bay, and therefore should be considered a Type 1 action according to Part 617 of said Environmental Conservation Law. Now therefore be it resolved that the town board does hereby receive and place on file the Town Planning Board Resolution 0861 dated August 25, 2008, and the Town Planning Department Recommendations Letter dated September 9, 2008, and does concur with said list. And it be further resolved that the town board does hereby determine the project to be a Type 1 seeker action and shall request from the other involved agencies lead agency status in order to comply with the requirements of the New York State conservation laws for the purpose of reviewing the aforesaid wiring project. And it be further resolved that a public hearing be scheduled in accordance with local law number 3 of the year 2003 upon the town board determining the application complete in accordance with the planning board recommendations.
A motion. Ms. Brockway, would you like to second that, Mr. Mannix?
I'll second it, and I'd like to ask a question if I could. In our resolution, might we not want to set a time and place for that public hearing?
If we, that might be wise. I don't know why that wasn't noted on there.
Normally, it's recommended that you get your lead agency status back. So you have one involved agency, the Department of Transportation, once they concur and allow you lead agency status, they may have comments. You may want to, do your public hearing before you get those comments. I don't know what they are, so normally you schedule after the comments.
Thank you. Glad you're here.
Now, with
And I
this,
thought I was going to win.
We know that, Alan, but
with this resolution, are we doing anything other than setting a public hearing to determine lead agent and determining lead agency status? Because if not, I have a couple of questions that were raised by the planning department.
I'm going to react to that, but Alan, please jump in. I think the answer to your question is yes. Through the public hearing process, we would anticipate some questions about the project might come forward, but it might also be wise, if you're seeing something early, that we address it.
My understanding is that this resolution, that we're claiming lead agency status, we're asking for recognition of that the purpose of this resolution is to notify two things. One, that we're asking for lead agency status, and two, we're recognizing that we need to have a public hearing in order to issue the special use permit.
I would just like to bring these up because I know they were questions during discussion at work sessions. On page 4, if you bear with me, I don't know if you have what was given to us, but the planning department recommends under section 20, the applicant requests relief to the application fees. The planning department does not have experience with town board actions authorizing relief from town fee requirements. It's recommended this request be considered at the discretion of the town board. And I know, Marty, you had some strong feelings about the maximum amount of the fees. There was a request made, and I didn't know if we were going to have that included. I just wanted to bring that up. It doesn't necessarily have to be decided tonight, but I know there was still some discussion, and that's why before if we aren't going to be held bound to any changes whatsoever, then I don't have a problem waiting until after the public hearing to move forward with the answer to that. And again, the second one, Jim, would be number 5 on that same page. Applicant request relief of performance security. The planning department recommends this request be considered at the discretion of the town board with advisement from the town attorney. I know that you had advised us on an earlier date that you didn't feel that there was a need for a performance bond because this is not the same magnitude as telecommunications. You still hold
yes.
that opinion? All right.
I think at this stage, I would assume that we'll be the lead agent, but or the lead agency, but that hasn't been determined. So I think we can set up the public hearing after, where we get that determination.
I don't mean to bog down these procedures,
No,
but I just wanted to ask the question
Sure.
just in case, because if there's some question that needs to be answered and we're going to be held bound
Sure.
without those answers, then I'm going to have to vote in the negative, but it sounds like we still have time, so
Oh, yes.
thank you.
Okay. Anything else? Roll call.
Sheila Brockway?
Yes.
Gerard Benedict?
Yes.
Martin Mannix?
Yes.
Brenda Bassett?
Yes.
Yeah, the applicant and your engineer there, you guys have any questions for them? They came all the way out here. Came all the way out.
We asked it, but as you can see, the requests for relief, the requests, plural, for relief, haven't been resolved.
Right.
Especially the
Well, I guess,
application.
right, the key tonight was
Yes. The
confirming
relief
the
is-
agency status, and as we know, we'll move forward, further those negotiations, and get you the other details that the planning department has asked, so that we can then... move
The
forward.
telecommunications one, that deposit, I think we were all in verbal agreement with the understanding if expert advice is required, it would be dealt with then. But the application one may not fly, just so you know. Okay, that will move forward. I would ask at this point for a motion go into executive session. A couple of items, one a personnel issue to deal with, another issue of litigation that we need to
I think we should identify the litigation and see. Harold Alford litigation's been around a long, long time, but it's something we'll talk about.
Local law requires that to be defined, Jim?
Yes, it does, yeah.
I didn't know if we had to protect the innocent by.
No, this is public record, so.
Do we have a motion?
I will move that we move into executive
I'll
session.
second.
Mr. Renadette, seconded by Ms. Brockway. Putting that in twice.
What's the personnel issue?
It's discussed what